if the parties were इतने समझदार होते थे लोग, तो शायद कोर्ट में जाते ही नहीं थे, या फिर पहले ही सेटल हो जाता था, या फिर वो पहले ही आपस में बात करके सेटल कर देते थे. But sometimes the role of mediator is important there. Those parties who cannot come to a consensus, that's where the skill of a mediator lies. Okay? So mediation is not just a legal provision. When I conduct say lectures or talks for mediation, I always talk it as legal provisions, science, and art of mediation. So there is a lot in it other than just legal provisions or the practical things. There's a lot of art involved in it. How we guide the parties or how we encourage the parties to come to a settlement is a realm of art. Okay. So in mediation, when I accept the parties who come to me that, okay, fine, I would agree to be mediator for you, it is very important that I should not have any conflict of interest either with the subject matter or with the parties. So that in short, I should be completely neutral, or mediator has to be completely neutral. I've just put one slide here to give you an idea as to the kind of thought process which goes behind it and why mediation can be successful, where a random negotiation between the parties might not have been successful in the past. Sitting at the table, when they come for the mediation, who sits where, how many people are invited, who all will attend, parties themselves can attend, their lawyers can attend, their advisors can attend, their relatives can attend, etc. But then, how is the power balance or equilibrium maintained? I cannot possibly allow 10 people from one side, only one person from the other side. That's going to be obviously unequal power equilibrium, as I would call it. Or I would, even if there is a say dispute between an employer and an employee, I possibly cannot offer a high chair to an employer and a low seating to an employee. There's obvious power imbalance there, right? So there's so many small details which go in the thought process. And that is the reason the possibility of success in a structured mediation with a hand-holding from an expert, there is a much better chance of success rather than random negotiations between the parties. It's like dieting करके result नहीं मिलता है, but then if the dieting is done under the supervision of an expert, say nutritionist or a physician, the possibility of success would be much higher, right? Because there a lot of science would go into it, a lot of experience of that person would go into it, rather than we trying to read Google and trying to do something on our own. So that's exactly how the mediation works. How do we choose the venue? Again, like I said, it should be neutral, impartial, easy to access, maintains part autonomy, so many things. Small details are taken care of while conducting these proceedings, and that's the reason it tends to become successful. Okay, my role as a mediator, when I'm acting as a mediator, I'm keenly interested trying to understand what are the interests, where the interests of the parties lie, what are the issues on which they are kind of not agreeing, what are the issues on which they are agreeing, both the things are easily agreeable. The proposals can come from either of the parties. So there could be some matters of principles for either of the party. It's non-negotiable. It's a matter of principle. Okay, for somebody, it's just matter of principle. It is non-negotiable. Then it's a no-go zone, like we say. Fine, it could be there. So we need to understand and be sensitive about them, the feelings of the parties, and then the Batna and Vatna or Malatna, which I have not added here. So best alternative to negotiated agreement, worst alternative to negotiated agreement, and Malatna, or most likely outcome after negotiated agreement. So we always try to give them an understanding as to, what could possibly be the worst case scenario, what could be the best case scenario, and what is the most likely scenario. And when we discuss these with the parties, they at times understand, how the things go. I'll just give you a random example here for you to understand. Okay, now just imagine a situation. एक किसी का बंगलो है, बंगलो में एक garden है, and there is an orange tree in it. The lady of the house, uska bacha ghar pe was not well. The doctor advised to make some kadha concoction out of the orange peel. So she was climbing the tree. to pluck the orange. It fell down from her hand, fell outside the compound wall. बाहर से रास्ते से एक आदमी जा रहा था, उसने वो ऑरेंज उठा लिया. All right. And then she went out saying कि नहीं ये मेरे ट्री से गिरा हुआ ऑरेंज है, I want it. And he said नहीं मुझे रास्ते पे मिला, ये मेरा है. Just imagine the scenario, right? So one party, both the parties are claiming ownership to that orange now. So there is a dispute here. So if one party decides to go to the court, क्या होगा? Okay, court will take. So this is when we make the parties understand. बांटना, वाटना, मलाटना, what I'm saying. Worst case scenario में क्या होगा? Court will take. The best case scenario में भी court 8-10 साल ले लेगा. And then फिर एक के पक्ष में decision दे देगा. Okay, you have a better ownership right than the other person over this orange for whatever the legal provisions under section so and so, so and so, so and so of Properties Act. All right. So लेकिन तब तो वो orange का क्या होगा? Is that orange going to be useful? Is it going to be useful to either of the parties? So that is the most likely outcome. In otherwise, what are your interests? Why do you need the orange? The lady probably needed the orange because she needed the peel to make the concoction for the child. The person probably wanted to eat the orange. So is it possible then that the lady takes the peels, the person takes the fruit of the orange inside, eats it, both are happy? Right? So this is what mediation can do, because we can create out of the box solutions. The legal proceedings are bound by word of statute, what is written in the law. It cannot exceed that. While in mediation, it is an art, like I said. So we can go beyond those words and really try and find the solutions. And as a result, then it becomes a very quick resolution. Typically, mediation proceedings can get over in 2, 3, 4 days, unlike 10, 20, 30 years of judicial litigations. Naturally, it's going to be minimally expensive, no expensive sharing of cost lawyers who's going to charge you per visit appearance charges, which will go on for a few years, much less stressful. Going to the court itself and standing in that box and acting as a witness is quite a stressful situation for most of the people. Well, here everybody is sitting nice, comfortably around a table, sipping a cup of coffee and just discussing or talking about it. So it's very informal, very flexible, like I said. Most importantly, both the parties have a complete control over outcome and voluntary exit option. तो एक भी पार्टी को लगता है कि नहीं मुझे प्रोसीडिंग कंटिन्यू नहीं करना है, the person has right to just opt out of it. There is no compulsion. You cannot opt out of a legal proceeding. जिसके ऊपर against case है, that person cannot opt out of the proceeding क्योंकि उसके against case है वो, right? Well, here both the parties have an option of just exiting anytime if they feel they're not comfortable with it or it's not going nowhere for that matter, and they have a complete control over the outcome. In judicial litigation, nobody has a control over the outcome. Judge can order dega. Do both the parties have any choice? No. They just have to accept whatever the judge will pronounce. And that's a word of God for them, or that's the truth for them, right? They have to just accept it. Whether either of the party or both the parties are happy with it or not. Both the parties are never happy with judicial litigation. Because naturally, हम court case में हमेशा बोलते हैं ये जीत गया. This party won the case. That means the other party lost the case, all right? So loser is never going to be happy about the outcome. Why? That doesn't happen with mediation. Two more important things. It provides a safe space for affording vents, confessions, apologies, which are sometimes, go to the root of the whole issue. Is for I had I'm not going to disclose identities. एक डॉक्टर के अगेंस्ट एक कंज्यूमर केस हुआ था, and there was some complication with a child and the parents had filed a consumer case. So that was going on for a few years, and that's when both the parties approached me for mediation in this particular case. Naturally, I spoke with the doctor. Okay, the other thing that we do in mediation is we are allowed, or we do conduct private sessions with both the parties. What does it mean? कोर्ट में जो भी बात होती है दोनों के सामने ही करनी पड़ती है. कोर्ट, that is a rule of law. Everything should be disclosed to the other party. तो जो भी बात होती है दोनों के सामने ही होती है. So whatever is spoken by one person definitely is known by the other party as well. And that's why the positions harden there. One cannot really afford to vent their confessions or whatever happens. While in mediation, we conduct private sessions. Means with the permission of the other party, सिर्फ एक party से बात करेंगे. We'll talk to that person whether what we have speaking now is in confidence. So whether it's going to be confidential unless you give me permission that I can disclose some facts to the other person. Otherwise, I will not disclose. So then both parties are very, very comfortable talking to me as a mediator and really opening or pouring their heart out. And that's when I can really, from their body language, the way the tone of their voice, the emotions, everything that comes out, it's my duty to really bring out those things and try and understand and go to the root cause of the problem. So the case that I was talking about, so when I spoke about all these things with both the parties, I realized that the parents of the child just wanted one thing. They did not want monetary compensation. But consumer court mein to compensation ke liye case jaati hai. The only remedy is compensation there, right? So they were not interested really in the compensation. But what they were mainly interested in was that fine, there was a complication. We are not saying the doctor has done it deliberately, but it has happened. So we would want just doctor to be sympathetic with us and say sorry and make sure that it does not happen to somebody else's child. On the part of the doctor was saying, it is a complication. I agree. I did my very best to, avoid it. But that complications are something which can happen. It's not a negligence. It can just happen. But I am not saying sorry because if I say sorry, it will be perceived by the consumer court that I'm guilty. And then it will be held against me. So I am not going to say sorry in the court of law. So that's why the case was dragging on. But there in my chamber, then it just sorted out within literally a couple of hours. The doctor said, I understand it happened. What happened with your child was really bad. I accept it. Even I am deeply moved. I am a father of a son. So I know what you are going through. I'm really sorry about it. We will be extra cautious that me and my staff, that, something like this will not happen again. The parents were satisfied with it. They withdrew the case. Within a couple of hours, it settled the matter. So this is what I mean. It provides a safe space for really bringing out the root cause behind the problems. And then it's a mutually beneficial or win-win situation because both the parties are happy. That's the most important thing in mediation. Okay. It also allows rapport building. Now, or rapport building or kind of a confidence in one another. Imagine an employer-employee conflict. Okay. I had one case where there was again a dispute which was going on. It had not gone to the court of law, but they had approached me before that. And when eventually it settled, the employee was so happy that employer did listen to everything, whatever I was saying, and was sympathetic to me, that he became one of the best employees going forward. The next year, he was awarded the best employee as an employee. Okay, so there is a rapport, there is a sense of belonging there then, which can develop. It often understands between the parties in an ongoing relationship. It allows creative solutions. Like I gave you the example of an orange. In court of law, that is not possible. Whatever is written in the statute or the act, the court has to pronounce that as a judgment, right? Court doesn't have a liberty to go out of box and do something. Only Supreme Court has the liberty, but no other court has that liberty to go beyond what is written in the law or the statute. So bespoke outcomes or tailor-made outcomes are possible with mediations. An opportunity for finality and closure, extremely important, extremely important. Judicial litigations go on for decades, 30, 40, 50 years. People spend their lives, their entire life savings in fighting a court case. And to what effect or to what end? The whole life is kind of, just wasted over that one judicial proceeding at times. And I really feel sad when I see cases like that. While mediation gives a finality and closure, within a few days, hours, days, there is certain closure to it. Fine, this chapter is over. Now I can go ahead and do something better. Compliance with agreement is usually high. Why? And the agreement doesn't require enforcement. Why? Now, court, even if the lower court gives an order that fine, this is what has to be done by one party. What if that party doesn't do it? Then again, the other party has to go to the court of law for execution of the decree or enforcement of the decree. And if that does not happen, go to the higher court or the superior court, and that whole cycle will start again all over again. And that's pretty high possibility, right? In mediation, it does not happen because both the parties have willingly come to an agreement or understanding. If one party had a feeling that I don't want to do this, that party will never agree to that understanding in first place. So we don't even need to write down. Of course, we write down the agreements, the parties sign, all those things are different, but it is not required. Because if there is true meeting of hearts, nothing else really matters then. So when I say art of mediation, it's like, when the parties leave my mediation chamber, what is it that I want? I, as a mediator, I'm trying to divide the cake in such a way that every person leaving the table goes back believing that he got the biggest piece. That is what is art of mediation. And that is what we are striving for. In short, everybody is happy about the outcome, and that's when it's going to really last.
हमें उम्मीद है कि आपको यह वीडियो अच्छा लगा। हम बहुत रेगुलरली मनी मैटर्स, हेल्थ और एंटरटेनमेंट पर सीनियर सिटीजन्स के लिए एक्सक्लूसिव वीडियोस रिलीज करते हैं। यदि आप हमारे नए वीडियोस को मिस नहीं करना चाहते तो नीचे दिए गए सब्सक्राइब बटन पर क्लिक करें।